Adam Flock, Alex Miller, welcome. Thank you for taking a few minutes to educate our clients and prospective clients. I know the topic today is a domestic asset protection trust, which your firm's been a big part of. But Adam, maybe give just a little background on RMP, and then we'll kind of kick it over to Alex to kind of get into the weeds on the topic for today.
Sure. So I appreciate you letting us be here today, Bentley, and Alex, my partner, is on the meet as well. And so our firm RMP is it's been around since about 2005. Is the most recent kind of iteration of the firm. But the roots go back, to back to the 1940s with E.J. Ball up in Northwest Arkansas. But the firm is primarily a wealth planning firm. So we work with a lot of high net worth individuals, both from a transactional point of view as well as estate planning and really generational estate planning. We work with a lot of clients on both large transactions and helping kind of structure that for these people that have kind of built up their portfolio and their business. And then when they sell it, then we help them kind of take that liquidity event and prepare it for the generations through estate planning. And so Alex is going to talk here in just a minute because his experience and practice has been pretty heavily involved lately on some of the legislation around the recently enacted domestic asset protection trust in Arkansas. And so we've been doing those for years, but we've always had to go out of state to a state like Nevada or somewhere like that to do it. And so this allows us to do it here in Arkansas.
Alex, why don't you give me just a 60-second background, just your overall practice, and then maybe just launch right into what a domestic asset protection trust is.
Absolutely. Well, thanks for having me, Bentley. My practice is very similar to Adam's. I consider myself a tax attorney, so I do a lot of estate planning, some business transactional work, and then also a little fighting with the IRS. I think as a tax attorney in the state of Arkansas, most tax attorneys, we all kind of deal with those three areas. Adam gave a brief history of our law firm. I'll give a little bit more. The firm was founded in 2005, and it was actually founded as a little boutique tax firm. I started in 2006, and at that time, there were four of us. And I think the first 6 or 7 attorneys here, we were all tax attorneys. And so, that's really, I still view this law firm as this little boutique tax firm, but we have 33 or 34 attorneys now, and I think probably 11 of us are tax attorneys. So we've obviously grown into more of a full service type law firm. In the years I've been here, I'm not going to say we've been really involved in the legislative process since the beginning, but probably the last 3 or 4 legislative sessions. So maybe the last 8 to 10 years. We've built relationships with legislators, reps, and senators that, sometimes we've gone to them and said, hey, we've got a law that we think would be beneficial for our clients and Arkansans. And this time around, back in 2022, I was actually approached by a senator and a rep here in Northwest Arkansas who was, interested in proposing laws in our area, in our industry, that would potentially spur economic growth and help some of our wealthy, and I guess they approached us because we tend to represent wealthy clients, business owners and people that have enough assets where they're worried about the estate tax. And so we were approached by some of these legislators that said, hey, what are some laws that the state of Arkansas can pass that can, try to keep some of these wealthy individuals, keep their assets here in the state of Arkansas? And the Domestic Asset Protection Trust was one of those vehicles, one of those laws that we came up with. We're not the first state to do it. In fact, we're the 21st state. There's 20 other states that have a Domestic Asset Protection Trust statute. A Domestic Asset Protection Trust, if you're asking what is that, what that is, and I like to speak in layman's terms, Bentley. I try not to talk over people's head and all that, but basically it allows our client to create a trust. It's an irrevocable trust, so it's not like a typical revocable trust that they can amend at any time they want, but the client can set up an irrevocable trust. They put their assets into that irrevocable trust, and the assets are protected from their creditors. In the state of Arkansas, we've never been allowed to do that. That law was passed and went into effect August 1st of 2023 this year. So it's a very fresh law here in the state. So that's it in a nutshell. I mean, obviously it's a lengthy law and there's a little more to it, and I'm happy to go into as much detail as you'd like.
Why don't you give maybe a planning case, obviously not using names, but that you're working on now, or what would be a likely set of facts where this is, this would be useful?
Well, it's really, I can answer that by telling you both a set of useful facts, a set of facts where it would be useful and not so useful. I actually met with clients this week, and I'll probably start there with one where it doesn't make a lot of sense. And so let's first just talk about what are the requirements to set up one of these trusts. I already mentioned, you need to have an irrevocable trust. So you got to be willing to set up this trust and put your assets into this trust that you can't amend. You also need a third-party trustee to be involved. So with most of our clients' revocable trusts, and most people that are probably going to watch this video, they're used to these revocable trusts that they serve as the trustee, and they have full control over how the assets are managed and full control over how the assets are distributed to the beneficiaries, including themselves. And so they'd have to be willing to have a third party step in, and it can be an individual who's a resident of the state of Arkansas, or it can be an Arkansas bank or an Arkansas trust company. The distributions that come out, so if you ever want money out of the trust, you have that trustee, that third party trustee has to have that final say on whether the money comes out or not. But really anyone, high net worth individuals with, business owners, people that are in professions where there's a lot of risk, a lot of potential litigation, doctors for sure. So going back to the story I started, I had clients that I met with earlier this week, and they come in, and of course, this is probably like a lot of clients that come in after they've already got an issue. And these clients said, hey, we're trying to figure out how to protect our assets. And as the story goes on, we realize they've been in a lawsuit for 1.5 years. And so one of the requirements for a domestic asset protection trust is you can't set it up with the intent to defraud current creditors. They would call that a fraudulent transfer and bring the assets back out of the trust that you transferred into it. And so you don't want to set one of these up when you are facing a lawsuit. You want to set it up, before those creditors are in front of you. But we are starting to talk to clients. Again, the law is very fresh, but we're starting to talk to clients that, like I said, it could just be general high net worth clients, but usually it's business owners or professionals that are in some kind of high liability profession.
Alex, this is a particular interest to us. Obviously, our clients can benefit from this, but we launched Naviter Trust last year. And so we think with this, fresh change, that there's probably some opportunities for us. Obviously, you can use the traditional corporate trustees, but my experience is that's not typically the best result. And so We're pretty excited that this may create some other other opportunities for us. Is there a limit to the amount of one's assets that could be placed in one of these trusts?
There's no limit whatsoever. I've pretty much given you the requirements. And so, just so you know, I didn't reinvent the wheel when we went and drafted this law. I went and, we researched what are the best laws from an asset protection standpoint, which state that has created these these statutes, which one's the most protective of our clients' assets. And so we pretty much went and we stole what the state of Nevada is doing. And they've had a statute out there for many years. There's no limit to the amount of assets that you put in there. like I said, it's just the trust needs to be irrevocable. You need that third party trustee. You need to make sure that the trust is drafted so that for distributions that come out, you at least have a third party trustee that has the final say. And the reason I said that, those two requirements may seem like the same thing, but the client theoretically can be a co-trustee. We usually recommend against that, but that's really the only requirements, other than what I said earlier, is that one of the purposes can't be to, defraud creditors in setting this up. But that's a very good question. Another thing that I think would be very interesting to your clients, and one of the reasons, there's really two reasons that we picked Nevada, and two major benefits that statute gave the clients over a lot of other states. One of those is the statute of limitations, meaning once you set up the trust and you transfer your assets over to that trust, how long does a creditor have to come after the assets in that trust? And the statute of limitations is 2 years. That's the general rule. And so now, theoretically, the assets that go into that trust are actually protected on day one, okay? But a creditor has 2 years to challenge that transfer if they can prove one of two things. And one of those is they can prove that it's a fraudulent transfer. And the other thing is if they're a judgment creditor and they come after the trust assets within 2 years of you setting it up. So the 2 year period is really nice because a lot of other states, they go as high as 5 years. So the assets are protected a lot quicker under this statute. The other one that can be a little controversial is the fact that there are no exception creditors under this statute. So a lot of these states that have enacted one of these statutes, they say, okay, we'll let you put your assets in this trust, but we're going to carve out an exception. For example, we're going to let your spouse, if you get divorced, we're going to let a spouse come after that domestic asset protection trust for alimony or child support. And some states even say if it's a medical malpractice case, we're going to let the creditor come after that doctor's trust. Arkansas says there are no exception creditors, so it's protected against anyone.
Hey, that is good news, and I'll tell you what. I'm guessing you would be willing to visit with our clients about this if the topic comes up and they're asking questions and would like to figure out if it's a good fit for them.
Well, there's no doubt that I would be willing to do that. Of course, I'm up here in Northwest Arkansas, and Adam's down in Little Rock, and we have Adam and I believe 3 other estate planning and tax attorneys down there that are more than qualified to do this for our Little Rock clients as well.
Well, we've worked with Adam and Joe and others in the firm for years, and have had a tremendous experience, and think highly of you all. Given that I believe that no one is going to watch more than 10 minutes of estate planning topics, I'm going to wrap up here. But I do want to thank you guys again, not just for showing up today, but the great work that you've done for our clients over the years, and look forward to doing more together.
Okay. Well, thanks for your time, Bentley.
We'll see you soon.
Thanks for having us, Bentley.
Thank you.